righty, so good afternoon, everybody. Welcome to the Masters Conference webinar series. Today, our focus is on generative AI and document review. My name is Kevin Clark, and I'm the Chief Legal Officer at the Masters Conference, as well as the CEO of eDiscovery. And I'll be the host for today's program. We'll be getting started with today's program in just a minute, but before we get started, just a few program details. I'd like to remind you that today's program is being recorded, and we'll be posting this onto the Masters website shortly after the event. I'll send out a link to the recording for all participants as well. We encourage you to ask questions at any time during the program by typing them into the comments field. And your question will be answered by the panelists or the moderator during the presentation or after the presentation at the discretion of the panelists. A little more housekeeping, some webinar ground rules. The content is for educational purposes only and does not constitute legal advice. Questions posed by and opinions offered by participants and panelists are for the sole purpose of improving our educational value and do not constitute legal advice. The views expressed by the members of the panel belong solely to the panelists themselves and do not necessarily represent the views or opinions of their organizations. There are no bad questions. Again, we're going to be taking questions throughout the presentation, but please type them into the chat box. Please remain on mute so that you do not create unnecessary background noise. The last piece of business to share with you today, we had 13 live events last year in the United States and in Canada and the UK. We have another full schedule set up for 2024. We have a Masters Conference coming up in Miami, hosted at Holland & Knight on February 22nd, next week, and another live conference coming up in Dallas on March 21st. We'd love to see everybody attend. If you're in the area, please come on by to our live events. For a full list of locations and dates, please check our events webpage on our website. And now on to our program. I'd like to introduce today's moderator, and she can take it away with further introductions. Melissa, over to you.
Thank you very much. Hi, everyone. It's good to be here. Happy Valentine's Day. I'm Melissa Weberman. I'm counsel at Arnold Porter. I'm the head of the firm's eDiscovery and Data Analytics Group also. And I'm so happy to be able to talk about such a cool topic. It's so rare to practice in this space and be the person at cocktail parties who want to hear about what we're doing at work. So super cool to be talking about this. What I'm going to do is very briefly ask each of the panelists to introduce themselves, what they do, where they work, and also just a little bit about their interest or experience with generative AI and document review. I'll say that my experience is we aren't yet using it for those purposes at my firm. So I am a great moderator because I probably have the same questions that you all do. So I'll turn it over now to Z. Please do introduce yourself. And when you have finished, why don't you hand it off to the next person? You can pick the person who you like best.
Oh, that's a hard one. Thank you, Melissa. Pleasure to be here. Zviad Guruli, I am Director of eDiscovery and Data Analytics at WilmerHale. I wear two hats. I co-lead a group of 120 discovery professionals, and I also practice all things discovery. In terms of the interest here, although GenAI is relatively new to the discovery world, I've been using forms of AI for many years. With first workflow I did early iterations of TAR way back in 2007. So I do think it has the new versions of AI that we are deploying has a great potential, and obviously interested and want to contribute, make sure it becomes in a responsible and effective way adopted in discovery community. So with that, and again, I cannot, with the Valentine's Day, I love you all. So, but we're gonna have to go with Tara.
Thank you. I love you all too. So I'm Tara Emory. I am the Senior Vice President of Legal AI Strategy at Redgrave Data, based in Washington, D.C. My work involves eDiscovery, information governance, and now AI. As far as my familiarity with it on a personal level, use it all the time, create things for other people with it, and think it's really cool. On a client side, I am building compliance programs and doing education for clients, as well as now starting to create a playbook for a client around potential uses of generative AI for legal teams. And then on a thought leadership or specific, I guess, to document review side, similar to Robert and Aron, have been involved in experiments testing the efficacy of generative AI against other types of review. Aron.
I'd like to first claim that I'm the second most loved person or the third most loved person in this group. I won't name a loser, but I'm the Senior Director of Applied Science here at Relativity. I lead sort of the traditional analytics, machine learning, sentiment analysis, TAR, conceptual search. Sort of that's in my portfolio, as well as all the new stuff coming out around generative AI. Relativity has a couple of products, one that's sort of already in market, which is Air for Review, and then a couple that are coming really soon. I got into this whole profession in a very funny way. I'm not a lawyer. I think I disclosed recently that my mom was a plaintiff's attorney, and so I did discovery when I was like a 12-year-old kid, like labeling boxes and doing case and trial prep for her. And then I went to school and I was a software engineer, and then I was a mathematician, and then I was a statistician, and then I decided that my true love was really legal technology. So that's where I am right now. I'll pass it over to Robert.
Thanks, Aron. Robert Keeling, head of eDiscovery and data analytics at Sidley. And I have a long history with what used to be known as supervised or unsupervised machine learning, which now seems to have been rebranded as AI by the legal industry. And then with respect to generative AI, we've been working on it going almost a year now. We started pretty heavy testing around May of last year on legacy matters. And now we are starting to deploy generative AI in live matters starting last month. So looking forward and very excited about that. I'm looking forward to obviously talking with everybody about it.
Thanks very much. So I wonder, Aron, if you might be able to kick this off for us, really level setting with just some sort of definitions or key concepts. If you could explain to us, what are large language models? What is generative AI? How is it different from the technology-assisted review, the supervised or unsupervised learning that a lot of us have been doing for a number of years now?
Yeah, thanks. I'm happy to get things started. I think that one thing that sort of can be confusing when you're hearing terms like generative AI or you're encountering GPT-4 in a professional context, and it's because the technology feels so disruptive and it feels so new that it came out of nowhere, and it didn't. We're on these long trends of discovery and development on the academic and technical side. And so terms like artificial intelligence are, 70, 80 years old at this point. A lot of the technologies that we use have been around for a very long time, but are, because of the way that technology works, rapidly accelerating in their capability. And so at some point, we take a look at a trend line of increasing capability or decreasing cost or whatever those sort of things adding up are, and we say, oh, wow. Where before it was wildly expensive to use this technology or tool in this particular way, this seems like a pretty reasonable cost. And now this technology has made it available. And so that's like sort of like the broad definition, the landscape that we're living in. That's AI. The reason we call it generative AI is really just an accident of timing. Stable Diffusion and these other tools that sort of create images from text sort of exploded into the public consciousness in 2022, 2023. And as people sort of got really excited about the ability to generate pictures of astronauts riding horseback on the moon, carrying a rose in their hand just from a text prompt, we also started realizing that this was a new way that we were starting to interact with computers and technology. And we thought that the most appropriate term at the time was generative AI. Now, if ChatGPT had come first, as opposed to pictures, it'd probably be called chat AI. Like, I have no doubt in my head that people would have associated the chat part and not the G or generative part. But because generative had already kind of made its way in, we started labeling everything generative AI, and we sort of looped or sort of grouped the latest technology advances coming in from text models, and they are related technically under the hood as well, into this sort of broad category. There's some other naming that people use. You'll hear people say frontier models to refer to any models that are sort of like the latest version or the latest release. And the Biden executive order also starts to kind of cut a difference between models that are sort of in the pre-GPT-4 era and the post-GPT-4 era. So anything sort of at GPT-4's capability or requiring a similar amount of training or investment is now sort of being treated differently and sort of has crossed into this new frontier. I think we've all heard the large language model definition before, but I'll just give it again one more time. A large language model is a component of an AI system. Frequently, it's only a piece. It's not the only part of the system, but it's a component of an AI system that looks at some amount of text and then predicts next words or generates responses if given sort of instructions in the beginning, sort of in line with whatever the text that they received was. And so a lot of the sort of core technologies, a lot of the advances that we're seeing right now in eDiscovery and sort of in the practice of law in general on the technology side, many of these advances are powered by these large language models.
So Z, I wonder if you can help us out with another concept that I've been hearing come up a lot and that lawyers, I think, are particularly concerned with. And that is, if you could explain to us the difference between what's known as an open versus what's known as a closed model. And, what is that and why is it that we're also concerned with that?
So I completely agree with Aron in terms of the technical aspects. I mean, and I defer to him on obviously on these explanations. There are different types of large models, though, in existence. And there are different ways to classify them. So in some instances, you can talk about large models that are like generic. And in terms of its purpose, there are ones that are multilingual versus there are others that are English only. There are as well models that are domain specific, task specific. It all depends how these models are deployed. Open and closed is another variation, and the reason lawyers are particularly concerned is that open large language models are publicly available. The source code is available. There is a certain level of community involvement and community contributing to its development, but obviously that raises some confidentiality issues versus the cloud, and some folks also refer to it as captive models, is that it operates, for lack of a better expression, within the organizational confines, right? So if you have a particular, so think of this way, if you had a client, and in legal industry wise, so if you had a client and a lot of repeat kind of litigations leverages the same data, same custodian. So imagine building a privilege model that operates within the confines of that particular client and the particular outside counsel. Obviously, there are less concerns with confidentiality and less concerns of it hallucinating and bringing in the context and stuff that from outside of the world. So that's another way to think about open and closed models.
So I think that's all really helpful to sort of set the stage here. I'm hoping now we can start talking about this as applied to document review. And I'm hoping that Robert can help us out with this, since he has been testing using generative AI with document review for, it sounds like, a year now. And he also pretty recently published something that explained some of the experimentation that he had been doing with, I think, Aron and others. Would you mind explaining to us, like, how this actually works and how it differs from TAR 1.0, TAR 2.0? That would be a big help.
No, happy to, and Aron can then fill in the blanks from what I get wrong. But like from a user's perspective, right? it's a really interesting issue because what we've been doing is we've been using for when we're going to do document review and we want to use machine learning or technology assisted review known as TAR. What we typically do is you identify training documents. So-called seed sets or training documents. Basically, you're identifying exemplar documents and you're telling the machine, the algorithm, hey, these documents are responsive and these are not. And the number or the volume kind of depends on your approach. If you're doing what's known as so-called TAR 1.0, you might have 1,000 or 2,000, maybe 7,000 training documents. For a more 2.0 or continuous active learning approach, you're going to have tens of thousands, hundreds of thousands, even more than 1 million of these training documents. And you're giving all these documents from your custodians or other files, and you're saying, algorithm, these documents are responsive, these are not. And then the algorithm takes a look at all that information, looks at the documents, breaks them down into parameters and other features, and then applies this algorithm to create a model. And based off that model, it then applies that model to the documents that you haven't reviewed yet. And it ranks the documents as essentially most similar to the responsive training documents or not. And that broadly correlates with how likely those unreviewed documents are, how likely they are to be responsive. Okay, and that's what we've been doing. And there's various workflows, as people know, but there's different kinds of algorithms, support vector machines, logistic regressions, goes on and on. But basically, the idea is you find training documents, you feed it into the algorithm, and it creates a model and applies that model to the unreviewed set. Using a GPT or a large language model is very different, right? Because if you've been interacting with ChatGPT, basically you're just entering small, short prompts and you're getting an output, right? So, hey, please write me a review for a high-performing associate, and out will come a prompt, right? So how do you do that, though, does that make sense to do it for document review? Because you normally think of GenAI as like generating something as opposed to, like, let's say, making a decision. So working with Aron and the Relativity team, we wanted to see, well, what would happen? And what we did is we took a legacy matter that, for whatever reason, had been fully coded, responsive and not. And we already had the existing, it was a settled matter, but we had the existing contract review guidelines. And so what we did is we just basically took the guidelines and put it into the LLM and basically had it, based off the review instructions, determine whether a document is responsive, much like a contract attorney would, right? So basically, we're asking here GPT, look at the review instructions, then look at the document and tell us if the document's responsive or not. It's a little more complicated than that, but at a high level, that's what we were doing. And then look at the review instructions again, look at the next document, make a coding decision, and then go on and on. And so in that sense, it's very different from machine learning, because instead of thousands and thousands of training documents, you're basically just providing it a prompt. And you're saying, use this prompt, this set of instructions, and then review a document, and then let us know if this document is responsive or not, much like a human reviewer would, right? And so then the question is, well, does it actually work or not? And what we found, interestingly, and I think as other people have found, is, frankly, surprising to me, it works way better than I thought it would. And now it may be a lot more complex than just feeding in it turns out, and we can talk about that in a little bit, but it turns out it's a lot more complex than feeding your review instructions in and getting the answers. But at a high level, you're giving it a set of instructions to the LLM, you're letting it review documents, and then it's making calls up or down on the document, much like a human reviewer would do.
So what you described conceptually makes sense, but I mean, if you're talking about a lot of documents here, seems like that would take a lot of time. What are the timing considerations with with a workflow like that?
Yeah, so it's a great question. So in some respects, it's faster, right, to get going, to get started, because you're going to write the review instructions anyway for your team. So you're basically just feeding the instructions in instead of getting started, like, indexing a population and then starting with your review, however you're going to do that. Now, there are timing considerations, though. For one, what we found is there needs to be some back and forth, likely, between you and the LLM, right? To improve performance. And we see that in other LLMs, just for other tasks, that if you're interacting with the LLM and giving it revised instructions based off the output, and like, oh, instead of doing this, do this, or use subheadings and bold the subheadings, and you can improve the output. That was our experience with using the GPT for a doc review, in the sense that, one, we realized that our review instructions weren't actually as good as we thought they were, and that there was ambiguity.
No, I have to interrupt. They were really good review instructions. Overall, very impressed. Not going to comment on other aspects of work product, but we were impressed by the clarity of the review instructions. They really helped.
Yeah, well, thank you. But what we didn't do is we didn't provide essentially the FAQ that we had created. So we gave the review instructions to the reviewers. They read it. They started looking at documents. They had questions where there was ambiguity. And in response to, I think, as a lot of people, we had a document that provided answers to those questions. We also, the reviewers also asked a lot of questions because there were a lot of acronyms in this case. And so we're like, oh, actually, those acronyms, here's what those acronyms mean, and here's why they would be relevant or not relevant. And we gave that to the system as well. And doing those two things dramatically improved performance. We had then 1 or 2 iterations with it, and we went from, I think it was in like the low 50s as far as precision, recall, things like that, to 85% recall with a similar percent precision, which is interesting by itself, because normally in a TAR review, recall and precision go opposite ways once you get to a certain point. Here, precision and recall moved in tandem, and they both got better in a linear fashion. So I thought that was interesting as well.
So a follow-up question to that, what you've described, that iterative process, strikes me as sort of a human process, humans identifying places where they aren't clear on things, ambiguity in instructions, ambiguity in defining acronyms or who people are. Do you have any thoughts as to how you identify those sorts of ambiguities if you don't have people raising their hands and asking the questions?
Yeah, and I'd be interested in others' thoughts. Our experience was that it's important to use samples. So basically, take whatever your prompt is, apply it to a small sample, representative sample, and then see what your output is. Because we were doing that, and we were catching these issues, and then we were looking at, oh, actually, it's coding this document responsive, but it's not. And it's also doing the same for these 5 documents that are similar. So we're going to revise our prompt this way. You revise the prompt, and then you run it against either the same sample or a new sample. And you keep doing that iteratively, because you don't want to just apply it to the whole population, especially if it's large. There may be cost implications for that. And then find out, actually, oh, your prompt was really unclear. So you want to revise your prompt as much as possible and make sure it's ready to go before you apply it to the larger population.
Melissa, can I quickly jump in terms of the point that Robert is just making? I think it's worth noting that there are different types of LLMs that are right now in use within discovery platforms, right? I think what Robert and Aron are talking about is more of a giving the memo, giving, let's say, request, and having the system make those decisions. But there are also chatbots that you can use within the discovery platform, which is different, right? So my recommendation would be use both tools, because at the end of the day, I mean, this is not going to eliminate tar. This is not necessarily going to eliminate search terms. It's another powerful tool or tools within the system. So worth distinguishing which LLM are you leveraging, because you can fine tune that quote unquote review aspect of it by asking questions. Now, some of the chatbots got so sophisticated that when you ask a query, it comes back to you and says, well, do you also want to ask the following? It starts even thinking for you that you might be missing something. So that might be one of the ways about you, to go to your question, how do you find those nuances that you might not be aware of, is to interact with the chat aspect of it.
Yeah, I'll comment on this because I think that this is the unfortunate place where two large groups sort of collide. We're constantly in a juxtaposition, right? So we have lawyers and legal technologists, and then we'll hit effectively the large language model training and building community itself. And then we'll sprinkle in marketing and everybody gets totally confused about what means what. So one of the most confusing terms that's being actually moved around in 2024 is fine tuning. And it got introduced, so I'm going to go ahead and sort of explain what it's meant historically and what it means now. Just like generative AI meant something different about 5 years ago, generative models meant something else. Fine tuning meant something specific and is now being used in a different means. So traditionally, and I know some folks have experience with these models, a fine-tuned model is a large language model that has been provided training examples similar to TAR. So if I have a 1 million document corpus and I'm perhaps generating, it doesn't have to be review decisions, it could be, for example, summaries on those documents, I might provide 5,000 examples of documents that I've had summarized into the large language model as a fine-tuning step to improve that. Now, that's the definition that a technologist or a computer scientist will give you if you ask about fine-tuning a large language model. In legal technology, where we're hearing fine-tuning is any kind of refinement to an input to a model that generates new outputs or sort of is to be applied at scale. So Robert's example of tuning his prompt, somebody would say that's fine-tuning. I would call that prompt tuning, just to separate the two. But if you're in a conversation with somebody and they're telling you that they're doing fine-tuning, ask them whether they're fine-tuning by providing examples to the large language model that the large language model then sort of takes in as a training step. It becomes part of the large language model. That's a really important aspect. We talked about open versus closed model. When you have a fine-tuning step, that model actually saves the information that was put in. If you're caring about like data security or privacy, that's something to keep in mind, is that saved model now has client information in it or whatever information was put in, versus prompt tuning, where the only thing that gets changed is this prompt, its set of instructions usually held outside of the model. And so you can have a situation where you do prompt tuning, and then when you're done with the prompts and done with that, the model itself was never changed. You can move on to your next workspace or next project. Whereas if you're fine-tuning a model by adjusting and giving it training data, that model may not be reusable between matters.
Yeah.
Understand the data moved around. Go ahead, Tara.
And I want to add on to that, and also Z's point, and wrap in Nordo's question here, is that we're primarily seeing three uses present themselves right now. One is query. You submit a query, and the system is going to go back and look through for similar documents and use those to summarize and explain to you and directly answer your question. So that can obviously have some really useful questions. I've also seen some cool demonstrations of this where, for example, it's like, oh, what question should I ask the witness about that? And it'll go even further using that information. So queries, direct queries are one use. The second one is summarization. And you could just ask it to summarize, but you could also give it a prompt kind of, in line with what we're talking about for review. But summarize it, keep these things in mind is probably going to be more useful to you, but you can create summaries and then keep them for various purposes. And also pull excerpts and whatever is going to be useful to you out of a document. And then the third one is, as Robert explained earlier, the predictive piece of it, where it could say responsive or not, or on a scale of 1 to 5, or whatever piece it is, but it's performing the function that is generally performed by any model that would do that. And so the ability actually to use it in multiple ways, even at the same time with the same type of query, is something. So this is Nordo's question now, is like, yes, you could ask it to review documents. You could tell it how to tell you if it thinks it's responsive, but you could also tell it to tell you what is responsive in it, or make other points, or keep its eye out for something in particular. So you can do these together.
So, and this also, by the way, Nordo's question, he noted that the process that's been described, sampling and revising, sounds a lot like TAR 1.0. And how is this process better than TAR 1.0? That really is one of my questions, and I wonder, Tara, if you can speak to this. I mean, we have tools in our tool belt that I think are pretty effective. I think
Right.
I think Cal is tremendous. I think TAR 1.0 absolutely has its application. How is this better, or even if it's not better, like what's the right way to use this in tandem with the other tools in our tool belt?
So I'll talk about traditional TAR as a whole here, and then we can talk about generative AI TAR. So one of the things that I was just discussing, where you can have it do other things while it's performing that type of function, is a benefit. Also, this group here has done studies. Redgrave Data teamed up with Relativity to design the experiments that were done by Relativity's clients, and then help evaluate the results. And we are seeing that, at least compared to human linear review, that you can actually get better on recall and better at precision. And that's before we get better at this. There are limitations, though. There's limitations of how quickly this can run. There's limitations on cost. You also had some really good questions earlier about the iteration process, and I don't know that we have enough experience at this point to say that that's really actually going to be more efficient or less painless for attorneys to have to generate solid prompts. And probably, like anything else, it may come down to skill as well. This is a skill that people may need to learn and get good at. And it may be like anything. If you have someone who really knows what they're doing, goes great. If you don't, doesn't go great. So, the question of is it better is going to be something that's probably going to be, it depends. It depends on the needs of your case. It depends on your budget. It depends on your document population. It depends what you want to get. So there is your lawyer answer, all in a nutshell. It depends.
It's industry specific too, right? In terms of who your clients are. So back in terms of the models in 1.0, 2.0, I've done cases where if you're dealing with a price fixing investigation or insider trading, where the client says there's nothing happened, but you still have to do your due diligence. There is no responsive document. So what are you really training, right? We used to do synthetic documents in those instances where we would create a fake document and said, if there were to be one, likely this is what the content would look like. I think some of the chat-based, from the three that Tara talked about, those going to be extremely helpful investigative tools in cases like that. So when you have, we also dealt with low prevalence and low richness cases. I still think in those instances, these types of tools will have much more effective results than what we used to do.
Yeah, I think, again, there's many more matters to be testing on this. But to me, it's the promise of much higher precision compared to 1.0. Because, look, we achieved 85% recall. If somebody's coming to me on the other side and we're in a case and they're demanding 85% recall in a TAR matter, I'm going to say no, because I know from experience that once I get past 75% and I get to, for most matters, to get to 80, but particularly 85%, I know my precision is going to drop significantly. And in order for me to reach that, I'm going to have large numbers of false positives, basically, to get to that. And, if us just in our initial testing can get to 84% precision on that, if the technology improves and now we're looking at north of 90% precision, now all of a sudden you're going to get more comfortable clients. You're going to get more comfortable with essentially using the tool as a replacement for first level review and just accepting the results of that and being okay with it, rather than going through a much more burdensome human review.
I think there's something to think about there, though. I mean, the way these tools are working, you get big buckets, responsive, not responsive, or just a few ranks. But in theory, at least in traditional TAR, Robert, even if you could get to 85% recall and hit 95% precision, if I were on a requesting side, and I do both, I would say, well, your results are going great. You can go to higher recall. Like, I don't know that we should assume that it's okay to proceed on what we're seeing, come out of the tools even, or that we've been using 70 to 80% benchmark in the industry, because there has been a shortcut assumption that it does get a lot more onerous to go past a certain recall threshold. So there may be, this is all to say, there may be benefit on both sides. Like, we may not totally resolve one side's precision issue and may not totally resolve the other side's recall issue, but maybe there's this will improve for both, and hopefully that is what we would see.
Yeah, I think that's a great point. And I think the other thing that's worth noting so far, at least where the technology stands, is if I'm using TAR and somebody tells me I need you to meet 80% recall, or call it 85% recall, I know I can do that, right? It may result in a big hit on precision to get the 85% recall, but I know I can do it. On a LLM, you're based off the prompt, and what we saw is wild swings in recall and precision based off changes to the prompt. Can I get to 85% recall with my prompt in an LLM? Maybe. We did it here. Could I do it on the next matter? I don't know. So that is one thing, that I think will need to be worked out as well.
And from the case scenarios, I think it's also important, since this is about AI and document review, privilege is a huge aspect of document review. Some of these tools where if we can advance them and improve the models, can you imagine them drafting initial iterations of Privlogs? And that would be a tremendous cost saving, right? So it's not just the content review, but there are other aspects of document review where this can be helpful.
I think there are a panoply of benefits. I don't even know if I said that right, but I'm just going to.
No, but
there are many benefits. That's right. This is why I didn't go to law school, folks. Yeah, many benefits. Some of them we haven't touched on yet. One interesting facet that we haven't really talked about is how few training documents you typically need to see before the model starts performing fairly well. And so typically we'll see people testing against a small sample of 50 or 100 documents, usually not more than a couple hundred, before the model starts performing where they want it to. And that's a massive improvement over a process like TAR 1 or TAR 2, where you have to see a lot more documents before you can kind of get confident that you have a good model or that you're done. And that means that fewer eyes on the documents. So if there are privacy concerns around the contents of the documents, instead of the AI sort of being a privacy risk, the AI reduces your privacy and security risk. It's a lot more consistent because there's only one sort of tool or sort of thing making the judgments on every document. You don't have 5 or 10 different reviewers, each with their own sort of differences in terms of context they're bringing in or sort of judgments that they make. You can kind of consistently say, well, if the first 500 documents were evaluated this way, I'm pretty confident that the next 500 will be evaluated in the same way, mistakes and all and not. The speed's pretty good compared to sort of like trying to calibrate a human review team. So I not just our solution, but there are many other solutions where you can just run something like 50 documents through and do that in just a few minutes. And so you can get your model calibrated quickly. And again, we're talking about what the technology can do now in 2024. It was just released a year ago, right? The sort of the frontier capabilities we're looking at. The possibilities for what it will be doing in the next year or 2 or 3 are tremendous.
So let me ask a basic question. Since we were talking about precision and recall, I just want to make sure that we're on the same page. How is it that we would validate one of these models? I think, Robert, we've talked about this before. I just want to make sure everyone's on the same page. How do we determine what precision and recall are when we're doing something like this, as opposed to the TAR review that we're all used to?
So to me, I think the established validation protocols that we've used for TAR will still work for an LLM review, and frankly, will be the path of least resistance because it's what everybody's used to. So in other words, like sampling on the null set, illusion sampling, however, there's a couple of different ways to go about it. But I think those ways apply equally to a LM set. Basically, you're just sampling the documents that here have been coded as by the LM as not responsive to see, are those in fact not responsive? Or is the tool missing something in some way?
So with validation, I think a lot of us have gotten comfortable with cutoff scores, right? If we're using a TAR 2.0 or a Cal type approach. But I think what I'm hearing here is that at least today, we don't have any sort of way that we would rank the likelihood of responsiveness. Rather, it sounds like it's an up or a down. How do we deal with that? And are we aware of any sort of technology on the horizon that might give us that sort of more nuanced approach of likelihood of responsiveness?
Well, the relativity tool does rank at least on a scale of 1 to 4, or however you want. I think there's a 0. So whether you could 0 to 4, or 1 to 5, or however you want to do it, but there is a ranking of confidence there. And and that you could apply, you could use that as far as, well, we'll have our top ranked documents definitely in, and then we'll do further review of the middle ranked documents. There's a couple different workflows to get at this, but it's not as precise, seemingly precise as let's say a TAR score, but of course the TAR score isn't telling you the percent responsiveness for that document. It's telling you the percent similar of the document is to the training set. So it it's a slightly different. It gives it illusion precision, but there is some correlation behind it.
We've been missing an API from the cloud services to give us the confidence in the likelihood from the model itself. That I can't speak to the specific date, but it is coming very soon. And then once that's available to us, then we can start incorporating it into our technology, and other providers will have it. I think that if you've seen the Google Gemini demo, you'll see that they did a very similar sort of document review task, and they used likelihoods sort of as part of the workflow. And so this is coming across the frontier models, not just the one that we depend on.
So if we could,
short-term pain in the next few months, and maybe something solvable later this year.
Cool. I'd like to turn now, and maybe Z, this is something that we can discuss a bit, and that is, how do you think we might deal with negotiating with opposing counsel if we do want to attempt to use large language models to help us with document review?
I think I'll start with the fact that it goes back to what Robert mentioned, which is same validation techniques apply. Right. So once we have done is this notion of don't worry about the magic box and don't worry about the process, etc. As long as you can validate at the end of the day, and we have those agreed upon, it will be easier. An interesting question from my perspective there, and this will go not just the negotiations, but how will this notionally change the concept of Rule 26 reasonable inquiry? When we talk about TAR and when we talk 1.0, 2.0, etc., I ask a lot in the industry and say, well, how many documents, like if you have 100,000 documents, can you review 5 and be done? Is 50 enough? Is 500 enough? I mean, technically, if you magically ask the perfect prompt and you load that memo, you could be done within 3 hours. Is that a reasonable inquiry, or are during the negotiations parties going to say, wait, that's just, you can't meet your obligations? So I do think, I am not one of those people who say constantly update the rules, but I do think that there has to be some changes made to the rules in order to anticipate a broader adoption of this. Because I can envision exactly the same problems that we had with TAR, and we can't have the search terms together with TAR because it's going to reduce by design your recall. So I do think we need to, as an industry, both the technical side of it and the legal side of it, develop some best practices, because it was the way different with TAR, right? Judge Peck wrote an article, that was the case, and then we started developing best practices. I think we need to get ahead of that. And the other aspect of this is the government. Let's not forget the government aspect of it. How many times, in contrast to litigation, have we given quote unquote non-responsive documents to the government in their inquiry so that they can get comfort level? What does that mean? Is the government now coming into outside counsel's office and saying, let me interact with your whatever the ChatGPT GenAI tool you have? I do think these things need to be considered before we even get to the point of negotiating and kind of reaching agreement with the requesting party.
Well, and Tara, I wonder if you can speak to this. I mean, Z, you described the perfect prompt, and and we could be done very, very quickly. We've become very transparent with opposing counsel a lot of the time in terms of, say, search terms. Might prompts be discoverable? Might negotiating prompts be the way to go? I mean, do you have any thoughts on that?
Yeah, I mean, I think this is a spot where it would be healthy if we could rethink how we've been doing things and how we need to approach this issue. There's no question that there is interest from typically requesting parties in sending prompts over. It's already been suggested to me quite a few times, like, oh, this is great. We just send our prompts over and be done with it, like you said. But you heard Robert writes really good review protocols. Aron signed off on that. I sign off on that, but that needed some finessing. So, and that's his own case. So if someone thinks that they can do better than that on the other side, they're not going to get a better result than the first prompt either. And this is just like keywords. You could be a great linguist. Your first shot at keywords don't reflect the content of the documents. And so, yes, I think like keywords, this could be discoverable in discovery upon discovery, because we know from keyword case law that generally courts will find that if it was a fact of discovery and a deficiency is shown, making the facts of discovery something that actually now has to be produced in the case, that may be discoverable. If it is work product, that's still pretty easy to break through if there's significant need, unlike attorney-client privilege. But I also know that these are like reviewer protocols, and when we communicate to our attorney teams, that's all behind a wall. That's our attorney work product, and we protect that. And so there is going to absolutely be unease with communicating prompts to the other side. So I do think any draft prompts are work product. If it's not the final prompt, then it's not a fact of discovery, and it shouldn't come up. But, I think that if you look at review protocols, they themselves can contain substantive information. If you really want to give your reviewers good information, you might be like, oh, and don't include this really personal information about someone if the document is not otherwise responsive. This example is not responsive. You don't just tell them what to look for. You tell them what not to look for. And when you're telling them what to look for, you might really be guided by your own view of the case. And so you might give them good instructions, but it really is the details that start to give away other things about what's especially in the not responsive document set that you don't want to end up in your produced set. And so I don't think that we want to create a situation where attorneys are dissuaded from making really good prompts, lest they be setting themselves up for discovery of these things they put into their prompts later. So I think this is something that we need to deal with. I think that when you define the scope of responsiveness, that is different. The scope of responsiveness should not change through this project. What you use to search for things within that scope can be refined and iterated. So whether it's a protocol or keywords, whatever it is, you can change that. So if the parties come to the table to meet on anything, it should be the scope of the issues that they agree are responsive. And I don't think that the RFPs and objection and response, that doesn't sum it up, because the sausage is made at the moment that all of those are rounded up with the complaint and anything else and put into a definition of responsiveness. And in fact, when I have worked as a court neutral TAR facilitator, So both parties already had to be very transparent because we're at the point where I had to be involved. I did require them to agree on the scope of the issues, not on the instructions given to the attorneys, not on exactly how the labeling looked, but on particularly what is the scope of responsiveness. And it prevented issues from slipping through that one side would have deemed responsive and the other side not. And it also very early on surfaced that one category that the requesting party wanted did not exist in the responding party's documents. The initial sample didn't show it. We ran all kinds of additional searches and it never showed up. So the requesting party was satisfied that they hadn't been ripped off by the TAR process. So those are the types of things that can build trust in a process. And I think that we can use them here, experience from TAR and keywords.
So, talking about scope, I wonder, Z, if we could kind of consider, though, the parade of horribles with what we're looking at here. I mean, you described the situation where you've come up with the perfect prompt and it takes 3 hours to come up with a production set. That's awesome. And, we've always, when talking about proportionality, have been thinking through, well, adding, say, more custodians, adding more data, it's more burdensome, right? But if you've come up with a perfect prompt and you can categorize the documents within 3 hours, you could potentially run the perfect prompt against all the data in the organization, right? So, I mean, where does this lead us and what do we need to be concerned about?
And that was kind of what I was alluding when I mentioned the need for having some kind of guidelines, right? And I say this frequently, and Tara and I talked about this before, and I completely agree with everything she said. Unfortunately, that's the world where two reasonable sides come together. But there is way too frequently we don't see that's the case, right? So, and what I mean by it, we still argue whether search terms and TAR can be combined, which is, to me, is nonsensical. And there are some jurisdictions who say that's not allowed. And I do have clients who say, and I think this goes to your question, Melissa, I do not want to use the TAR because I don't want to spend motion practice or negotiating outside counsel hours and arguing whether I combine these two tools, but then arguing whether I should give them non-responsive documents, then et cetera, et cetera, et cetera, et cetera. And what is exactly the 75 or 80% recall? And on top of it, requesting party saying, you know what, you have this wonderful tool that does magic. Just load all the document, completely disregarding the cost of it. I think we have a question in the chat, right? AI is not cheap. So adding that element, are we going to disregard how much it costs to host and continue and the data and cyber implications and all of that? So I think if we do put some guardrails, there is the downside that the adoption will be halted because of the exactly same or similar challenges that we had with TAR.
Let's talk a bit more about cost. And Robert or Aaron, I think I'll put you on the spot to just speak a bit about what's currently available. How expensive is this? The tech itself, and then all of the additional work that goes into it.
I'll let Aaron talk about specific costs. I have then a response about what that means.
Okay, I'll go first. I can't speak to the specifics of costs. I can say that for the customers that we are working with right now, the costs are cheaper than contract reviewers, but not necessarily as cheap as sort of deploying a trained TAR model, which costs something to build typically. So the costs are somewhere between there. The models themselves are not cheap to run, and so those costs are sort of being built into the prices. My broad statement that I sort of give folks is generative AI is coming, it is here. This is a way that you can start to incorporate it into your workflows in one of the most defensible, easy to test, easy to verify, easy to learn ways. And so it is a way for you to get a jump start within your organization on the broader impacts that these technologies and tools will have. So in addition to the benefits you have of adoption, you'll have the benefits of reducing your costs. There's a third primary benefit, which is that you will start moving some of the value from the spend you're currently doing on costs into the merits of your case. Because The documents generate more than just labels. They generate summaries, they generate citations into the text. They help you think about things that might be missing in your review protocol. And they do that all in ways that sort of were harder to do with sort of more traditional methods. So those are kind of like the three like benefits that you're getting for sort of one investment or bet. I actually think that pricing is not the thing that is causing most people to hesitate. It's the thing that we just talked about, which is all of the potential headache of negotiating with requesting parties.
Yeah. And I think that, you know, it's not just review 5 million documents this way or review nothing, because you don't want to do that. There are ways to approach this, selecting certain documents first that can go through. And the other thing is to use it in tandem with things you're already doing. To get your toe in the water. If you're interested and you want to see how it performs for your types of matters, then this is a good thing to try a little bit at a time maybe, and just see how it performs for you. And so clients that are doing this are, you know, using different types of sampling. And actually in the experiment that Redgrave Data did with Relativity, we used like a 2-phase sampling to get the absolute most out of the resources available to us. So it was like, here's how much you can do, and now do the most you can with it. And so to try to focus the review where we wanted it, including of our senior attorneys, like that was another limited resource to have them checking the work of the LLM. So we used a weighted type of sampling to help people get the most information out of what was being done. So, you know, if you're interested in this, but the cost is a problem for looking as a complete substitution to your existing processes, I'd say you can use it as a complement, and you can do what you're comfortable with for that.
Yeah, I agree with that. Bottom line is, if you're going to use this technology, you should strongly consider changing your workflows. If you're using your same workflows and you add in this, you're going to spend more, just because the machine learning technology is very mature now, and the prices reflect that. And so if you're going to throw, if you're going to throw the same amount of attorney time on a matter while also doing using an LLM, you're going to end up with a more expensive review. So you have to think about streamlining either your first level review or some other aspect of it to, you know, reduce the human input into your review compared to a traditional TAR review.
Well, do you want a last word? I think we're just about at time.
It's here to stay. And I think that would be it's not going anywhere. It just use it, as I said, responsibly, safely, and understand what you're doing with it. But to just close the eyes and saying, there are too many risks, and even though I alluded to many of them, it's here to stay.
I think we have to leave it at that. It was great having this discussion with you all. So good. You all are so good. And I just can't wait to continue the conversation. I hope all of you enjoyed it. And again, happy Valentine's Day.
Excellent. And let me just add, thank you, Melissa, for moderating. Thank you, Z. Thank you, Robert. Thank you, Aron. And thank you, Tara, all for participating. It's great session. And I really enjoyed hearing everybody's thoughts. So thank you all. Happy Valentine's Day. Take care.